As you all are aware, we will be discussing today the manner of passing the judgments in civil cases. You know, there is Order 20 in the Code of Civil Procedure 1908 CPC, Order 20, that deals with the judgments in civil cases. A formal definition of the word judgment has been given in Section 2, subsection 9 of the CPC. This Section 2, 9 says a judgment is the statement of the judge behind passing of the decree or order. Basically, the decree. It is a statement of the judge, a statement of the court behind the decree. What does this expression statement mean? In the context of a judgment, in the context of a decree, a statement here means the material facts, the material evidence brought on record by the parties, the relevant law that is attracted to those material facts and material evidence, and the reasons, the findings which the judge records in the judgment for passing of the decree, and then conclusion. So these are the prominent components of a judgment in a civil case. We will be discussing all these aspects one by one, and of course, with the help of leading judicial pronouncements of the Supreme Court and those of various high courts. So those who are lawyers among you and participating in today's discussion here, and those who are senior students who are aspiring for judicial service of the state of Maharashtra, or those who are planning to join the litigation, they need to know what is the role of a judge, what are the functions and duties of a judge while passing a judgment in a civil case. There is a write-up of mine on my website, lawhelpline.in. The title of my website is Law, all in small letters without space, lawhelpline.in, which Malvika was just referring to, and she has perhaps shared this website of mine with you people in your chat box. So you can open it and you can keep pace with what I am telling today to you by keeping in touch with the contents of the subject, judgments in civil cases. It is available on my website. You can locate it. You can just open it, lawhelpline.in. You know, there is no form or format provided in the CPC or elsewhere for passing a judgment in a civil case. In fact, the Supreme Court says that a judgment requires a lot of skill. Of course, the knowledge of the laws, the knowledge of the procedure of the court, and the practices that have been settled over the decades by the courts, especially by the courts of records. You know which courts are called to be the courts of records? The Supreme Court and the High Courts. This district court, district judiciary, different types of tribunals, they are not court of records. If they lay down certain principle of law, that is always subservient to the overall authority of the law propounded by the court of records. The rulings, the precedents are set by the Supreme Court, by the High Court. And technically, these two courts are called to be the court of records. So with the help of the leading judgments of the court of records, that is of the Supreme Court and of the High Courts, I will take you through these subjects which are under our discussion today. So judgment writing is an art. You know, any art has its own features. To have excellence in a art, it requires a lot of knowledge, a lot of skill and experience. So is with the writing of judgments. So what are those laws which a judge must know for purposes of passing a judgment in a civil case? The law contained in the CPC, particularly those parts of the CPC which deal with the pleadings. Which order of the CPC deals with the pleadings? Order 6. Then order 7 and 8. Order 7 deals with the plaint. Order 8 deals with the written statements which are filed in response to the plaints. There are basically three orders in the CPC: Order 6, 7, and 8, which deal with the pleadings. Then which part of the CPC deals with the judgment? Order 20. And then what is 21? Order 21 deals with the decrees, but you are today discussing Order 20, judgments. Our discussion today is on judgments. A judgment in a civil case contains these things. The components of a judgment in a civil case, I am enumerating to you. First one is the pleadings, the facts. Where from these facts are taken? From the pleadings stated by the plaintiff and the defendant in the plaint and in the written statement. Material facts are taken from the pleadings of the parties. The first thing which forms the part of a judgment is the pleading. Pleading is the relevant facts stated by the parties either in the form of plaint or in the form of written statement. The facts are taken for judgment from plaint and the written statement. The first component of a judgment is the fact. Number two, the evidence which the parties lead on these facts to prove these facts. Mere facts pleaded in the form of pleading in the plaint or WS will not suffice. If the facts stated in the plaint or in the WS are not proved, so they will be treated to be unproved, not proved, and the case will fail. The party would fail in proving its case. The first thing is fact. Number two is evidence brought on those facts. Number three is the law, the relevant law which is attracted to such facts and to such evidence brought by the parties on record. And number three is the finding, the reasoning given by the court. You can call it finding or reasoning. Then out of these reasoning, the conclusion to which the judge reached in the judgment. And then operative part of the judgment. You can enumerate the basic components, prominent components of a judgment in a civil case with me. Now enumerate. Number one, facts. Number two, evidence. Number three, relevant law. Number four, reasoning or finding. Number five, conclusion. And lastly, you can say what relief has been granted or refused by the court. That forms part of the conclusion. But for your purposes, for your convenience, you can identify it separately, the relief granted or refused by the court in the judgment. So I'm again reminding you about the components of a judgment in a civil case. Number one, fact. Number two, evidence. Number three, relevant law. Number four, reasoning or finding. Number five, conclusion or the relief granted or refused by the court. I was quoting a case, leading case of the Supreme Court reported in State Bank of India versus Ajay Kumar Sood, 2023 Volume 7 Supreme Court Cases, 282 para 17. In this case, Supreme Court says what is judgment? A judgment is manifestation of reasons, and judgment writing is a critical instrument in fostering the rule of law. Supreme Court says it's an art. Judgment writing is an art requiring a lot of skill. Judgment writing is a layered exercise. You know कि a judgment is completed in different stages. First stage of a judgment is recording of the facts, stating in the beginning of the judgment the facts, the most relevant facts of the case are recorded. I was telling you where from the facts are taken from the pleadings of the parties. Suppose that there is suit for permanent prohibitory injunction. A civil suit is there. It has been argued finally, and a judgment has been reserved by the court. And court is now dictating its judgment. So which part of the judgment will be dictated first? The fact part. In the beginning of the judgment, in brief, the necessary facts are written first. Then issues which arise out of the facts, out of pleadings of both the parties, those pleadings are written. Then the oral evidence which is led by the parties, primarily by the plaintiff by examining himself and his witnesses. Their names are written. His witnesses have been examined and their depositions have been recorded. Then the documents which have been produced and proved by the plaintiff, they are referred to. Then the defendant and his witnesses are mentioned and the documents produced by the defendant. Then in the center of the judgment, a heading is given, findings, and thereafter the court records its findings issue wise, and then in the last, the conclusion which the court has reached is written. What is called operative part of the judgment. That means the relief granted or refused by the court. And then the signature of the court is of the judge is put on the judgment seat. So these are the stages. What the Supreme Court says, there is a layered practice, layered method in writing the judgment. If you want to have absolute clarity with regard to writing of the judgments in civil cases, you must read the judgment of the Supreme Court pronounced by it in the case of State Bank of India versus Ajay Kumar Sood, 2023, Volume 7 Supreme Court Cases, 282, Para 18. Then I am taking you to the next point, essentials of a judgment. You can say that the components of a judgment are essentials of a judgment. In every type of judgment, these are the essentials, particularly in a civil case. The concise statement of the case, points for determination, what are called issues, decision therein by the court, reasons for such decisions. And this case is Cellular Operators Association of India versus Union of India, AIR 2003, Supreme Court, page 899. I'm again repeating this case, Cellular Operators Association of India versus Union of India, AIR 2003, Supreme Court, 899. Then there is another case, Union of India versus Manager, Jain Associates, AIR 2001, Supreme Court, 3381. And last case on this point is Balraj Taneja versus Sunil Madan, AIR 1999, Supreme Court, 3381. So these are three leading cases of the Supreme Court, wherein Supreme Court has clarified what is the stepwise duty of the judge while passing a judgment in a civil case. In the very beginning of this talk today, I had pointed out at number 1, the court records in the judgment the fact, issues, evidence, reasoning or conclusion, and operative part. Then signature of the judge. These are the essential parts of a judgment in a civil case. Point number 3A of my writing, of my write-up on this subject, as available on my website lawhelpline.in, is what a judgment must contain. These things which I just enumerated, 5 or 6 things, they must appear in a judgment in a civil case. And the case law is Sakuntala Shukla versus State of UP. You can note down the case or you can find it on my website on this subject. Sakuntala Shukla versus State of UP. AIR 2021, Supreme Court 4384. These are a few cases where the Supreme Court has clarified what could be the essential components of a judgment passed by court in a civil case. I had invited your attention to the fundamentals, the integral parts of a judgment, the most essential components which must find place in a judgment passed by a civil court in a civil suit or civil case. So far, I have covered for your knowledge to what can be the components, essentials of a judgment in a civil case. If you have any queries on this point number one, components of a civil judgment, components of a judgment passed by court in a civil case. If you have any query on components, any doubts, put your questions. Please feel free. Don't show hesitancy. Ask your questions and seek clarifications. I'm waiting for your queries, for your questions to offer you my clarification. Please ask questions. Let it be a participative, interactive session. Don't let it be just one-sided exercise on my part. You feel free. Don't hesitate. Put your questions and get clarifications, but only on this point, because I will be covering other points later on. Components of a judgment in civil case. Ask the questions.
So there's one question. What aspects of pleadings are included in the first part of a judgment?
You know, pleadings are details of facts written by the plaintiff in the plaint or by the defendant in the written state. It's not necessary for the judge to reproduce the entire pleading stated by the parties in their pleadings in the plaint and the WS. Only that much part of the pleading has to be taken from the plaint or WS to be incorporated in the judgment, which is necessary for deciding a particular issue that has arisen from the pleadings of the parties. You know, in a civil suit, more than one issues are framed, at times 10, 20, depending upon the controversies involved in the case. There is no fixed rule how many issues can be framed in a civil suit. It depends upon the nature of controversies, extent of controversies involved in the civil suit. So suppose ki, if a plaintiff has filed a suit for permanent privatory injunction against the defendant, seeking relief of permanent privatory injunction, you know a civil suit can be decreed only when the plaintiff proves his title in the disputed immovable property. And if the plaintiff fails to prove his title, his suit would be dismissed. Suppose the plaintiff has stated in his plaint that he is the owner in possession of the disputed land, disputed house through a sale deed that was executed in his favor by Mr. X. And this sale deed, either in original form or its a certified copy, has been filed by the plaintiff on record. And issue number one is framed in the uh, civil suit to whether the plaintiff is the owner of the disputed property as stated by him in his plaint. I'm again repeating the issue. Whether the plaintiff is the owner of the disputed property as claimed by him in the plaint. This is the issue. The case of the plaintiff as pleaded by him in the plaint is that he is the owner of the property through a sale deed, registered sale deed. So how much part of the fact from the plaint of the plaintiff would be assimilated, would be made part of the judgment, would be reproduced, would be quoted in the judgment of the court on the point of title? Only this much, 3-4 lines. The plaintiff claims in the plaint that he had purchased the disputed property through a registered sale deed dated so and so that was executed in his favor by the seller so and so. And since the date of sale deed, he is the owner of the property in dispute. Only this much should be written in the judgment of the court. Only this fact needs to be stated on issue number one, which has been framed with regard to the title of the plaintiff. If possession is also disputed, if the suit, as per the plea of the defendant, is time barred, and if there is non-impleadment of necessary party, as per the plea of the defendant, these things cannot be assimilated, cannot be added in this issue, because this issue relates to only pleadings or to only title of the plaintiff. So only that part of the fact contained in the plaint has to be quoted on this issue in the judgment, which relates to the title of the plaintiff. It is not permissible for the court to add all the controversies, all the disputes which have arisen between the parties relating to different issues, just in one issue which relates to title. So if it is a title related issue, then only title related pleading should be referred, and this should be done issue wise. If there is a issue of limitation, then the facts which have been stated in the plaint, how the suit is within limitation, and the plea taken by the defendant in his written statement, how the suit of the plaintiff is time barred, only that much part of their pleading should be quoted on the issue of limitation period. When an issue relating to limitation period has to be decided, then the facts relating to the title as contained in the plaint and WS must not be mentioned. You know, eh, an issue relating to the title of the plaintiff has already been framed, then why to repeat those title related facts with the issue relating to limitation? When particular controversy wise issues are framed, then only those facts should be stated which are relevant to that issue. It is highly absurd practice that on each and every issue, unnecessarily, the entire pleading is reproduced. If the judge knows his art, knows his function, so he will refer from the plaint and the WS only that fact which is relevant to the issue under discussion, which needs to be decided under that issue. So I think I have sufficiently explained
Yes, sir.
in response to the query which you put.
Yes, sir. So the next question is, how much time do judges generally take to write a judgment?
It depends upon the, in law, Order 20 says, 20 Rule 1 says, normally a judgment should be pronounced within 30 days from the date of conclusion of the arguments. And if for any exceptional reasons, rare reasons, a reason which prevented the judge for not being able to pronounce the judgment within 30 days, then he can, by recording the reasons, take next 30 days. It means that within 60 days, the judgment must be pronounced. But these are only directory things. Suppose if within 60 days the judgment is not pronounced, what will happen? A judgment is pronounced after 60 days, 90 days, 100 days, the judgment will not be invalid. It is just a breach of directory provision. And when only a directory provision is breached without causing any prejudice to any of the parties, then such breaches of procedural law are not fatal. So simply because judgment could not be pronounced within 30, 60, or 90, or 100, or 200, normal practice should be followed by the courts. It is misnomer that a judge must take 30 days to pronounce the judgment. No, if the judge is able to pronounce the judgment today itself, he must pronounce it today itself. Suppose that arguments of the parties concluded today. Counsel engaged by parties concluded their argument only today in the forenoon, and the judge is in a position to dictate the judgment and pronounce the judgment today itself. He can do it today itself. Both the things happened only today. The lawyers concluded their argument today, and in the post-lunch period, the judge nothing wrong in doing so. But all the courts in India are overworked, preoccupied. A lot of work is there pending with the courts, and they get engaged throughout the day in dealing with number of cases. So normally, it doesn't become possible for a judge to deliver the judgment then and there. And moreover, before preparing the draft of the judgment, a lot of attention is given by the judge to the pleadings, to the evidence, to the issues involved, and then he makes up his mind after studying the record, the file, and then he makes up his mind and gives dictation. And if there are any errors, virtually you can say that there is a period prescribed in Order 20, Rule 1, 30 days and then 60 days, but it doesn't mean that after 60 days judgment will be bad. It will be still valid judgment if it is otherwise valid on touchstone of the evidence and the law. All right.
ओके सर। सर हमारे जो पार्टिसिपेंट्स हैं वो लोग जुडिशरी एग्जाम्स के लिए प्रिपेयर कर रहे हैं, तो सर उसकी तैयारी में जजमेंट राइटिंग बहुत ही इम्पोर्टेंट है, तो उसके लिए आप कुछ टिप्स देंगे?
For those law students who are preparing to be the judges in Maharashtra judiciary.
Sir, they appear from Maharashtra judiciary also, and then also UP, Hindi, where states where Hindi is the language used.
यहाँ तो हिंदी परेशान करेगी, हिंदी में लिखेंगे।
सर अटेम्प्ट करते ही है जी सर।
हाँ, आए हैं कई कई आए हैं, जजेज हैं हमारे महाराष्ट्र के भी इधर हैं। तो हमारे ऑनरेबल राम नाईक साहब गवर्नर थे, तो उनके पड़ोस में वो लड़का रहता है, आजकल गाजियाबाद में कहाँ है वो, जज है, सीनियर हो गया है, डीजे डायरेक्टर जेएस आया है। तो शुरू में ही फेल्ट a lot of difficulty in writing and understanding Hindi because either he knew English or Marathi, but later on he excelled in both. He was quite comfortable in English and subsequently he gained
All the three languages.
yes, now he is a very very good judge in UP.
Okay sir.
नाम मेरे कुछ का भूल रहा है। So for these aspirants who are trying to get a berth in judiciary in Maharashtra or elsewhere in India, for them I will speak, they should just go through the formats of judges, the samples of judgments which are given in some textbooks, or they can procure it from the civil court, principal civil court in your city of Bombay. Basically, it is injunction suit, money suit, money recovery suit, suit for recovery of possession, and suit for specific performance of contract. So these are a few suits which are generally filed by the parties. Then there are suits for declaration of rights and status and title. So these 5-6 types are civil suits are filed in civil courts, and provision for these suits are there in the Specific Relief Act 1963. These students must be knowing that there is a parliamentary act called Specific Relief Act 1963. Injunction suit, suit for specific performance, money suit, declaratory suit, suit for specific performance. So these are there. So they must know how these judgments are passed. You know when there is a suit for specific performance of contract, then pattern of writing of the judgment would be a little bit different. The requirement of that judgment would be different from that of a judgment to be passed in a suit for permanent injunction. In permanent injunction suit, it is the title that will be proved by the plaintiff. But in a suit for a specific performance, the plaintiff will have to prove that he has always been ready and willing to perform his part. And it was the seller defendant who breached the terms and conditions of the agreement and did not perform his part. So this readiness and willingness requirement is not to be stated and not to be discussed in the judgment in a suit for permanent injunction. So when the nature of the suit changes, nature of relief changes, then the nature of judgment also changes. The requirement of the judgment also changes. In a injunction suit, title has to be discussed. In a suit for possession, the entitlement of the plaintiff to possession has to be discussed. In a money suit, the liability of the defendant in favor of the plaintiff has to be discussed. And in a suit for a swift performance, besides other things, the readiness and willingness of the plaintiff has to be discussed. So these students must learn to when the nature of suit changes, then the nature of judgment also changes. If there are students who are preparing for judicial examinations, so ask them to seek further questions, further clarifications from me, and ask them not to be hesitant, feel free, and put their queries. I'm waiting.
Good afternoon, sir. Little bit regarding the counter claims and the framing of issues, like what are the facts, what the facts related to the law, I mean the question of fact or question of law, and how it reflects into the judgment.
Yes. Question of fact always requires evidence. A party will fail, the plaintiff will fail if he fails to prove a fact pleaded by him. But when it is a question of law, so then you know section 56 and 57 of the Evidence Act say that the court may take judicial notice of the law. Law cannot be compromised by the parties. Law cannot be diluted, cannot be pressed to the court to be ignored. And when it is a counterclaim, the counterclaim order 8 rule 6A CPC. A counterclaim is a cross suit. The defendant is under burden of proving the relief, the cause of action, his entitlement, which he claims in his counterclaim. So just like a plaintiff is under burden to prove his case by means of his evidence, so is the defendant when he has set up a counterclaim. Counterclaim is called cross suit. The burden of proving the cross case, the counterclaim, lies upon the defendant. And if the defendant fails, his counterclaim will fail. So just like there is a burden on the plaintiff to prove his case, so is the burden on defendant. But there is Supreme Court ruling, a number of rulings of the Supreme Court, so where both the parties have led their evidence. There had been a contest between the parties, and parties had led their respective evidences. Then the question of burden of proof loses its relevance, its significance. Now the entire evidence brought on record by the plaintiff as well as by the defendant will be read together, and a finding would be derived by the court. I think you have got the answer to your queries. And if you have not, then again repeat which part of your query has not been answered by me so that I may be able to clarify it again.
Thank you, sir. I got the answer.
Right. More questions?
Yes, sir. Sir, there's one question. What are the key points of difference between a civil judgment and a criminal judgment?
Right. You know, in a civil case, the burden to prove his case lies upon the plaintiff. Once the plaintiff discharges this burden, then this burden shifts to the defendant. And if the defendant fails to shift this burden to the plaintiff, then the suit will stand proof. But in a criminal case, the burden to prove its case constantly lies upon the prosecution. Burden is never upon the accused to prove prosecution's case. But another difference is the principle of preponderance of probabilities is applied in a civil case as regards the question of burden of proof and assessment of evidence. In a criminal case, the proof is not preponderance. It should be always beyond all reasonable doubts. This reasonable doubts principle is not applied in the case, in a civil case, in the case of judgment to be passed in a civil case. In a criminal case, burden of proof is constant upon prosecution. In a civil case, it is not. Once the plaintiff discharges this burden, it shifts to the defendant. And if the defendant repels this burden, then again it comes to the plaintiff. It's a football type thing. If the plaintiff fails to kick back it to the defendant, then plaintiff will fail. And if the defendant succeeds in kicking back this burden to the defendant, then plaintiff will win. If a civil suit is filed by plaintiff, so who is under burden to prove? Plaintiff, whose suit would be dismissed if the case is not proved? It is the plaintiff. Loser would be the plaintiff. In a criminal case, burden to prove its case is constant, is permanent upon the prosecution. Another thing is the standard of proof in a criminal case is proof beyond all reasonable doubts. Guilt of the accused should be proved beyond all reasonable doubts. But this is not the standard in a civil case. So primarily these two things are there which differentiate between a civil suit and a criminal case as regards the standard of proof.
Okay, sir. Sir, next question है, what should be the length of a judgment?
There is no prescribed length. In some cases, Supreme Court has ruled brevity adds clarity. Brevity. Brevity adds clarity. Whether a lengthy judgment is treated to be a good judgment. I am pointing out a case, Union of India versus ESL Mining and Industries Limited. It is 2005, volume 6, Supreme Court cases at page 675. Again, pointing out the citation, 2005, volume 6, Supreme Court cases at page 675. Supreme Court has said in this case, writing unnecessarily lengthy judgments than required should be avoided. It is not the number of pages in a judgment, but sufficiency of reasons that matters. Soundness of reason, logics, and the findings, the conclusion matters, not the number of pages. A lengthy judgment is not always excellent judgment, and a short judgment is not always a bad judgment. So there is no prescribed limit, prescribed number of limits to be covered in a judgment. Then what is necessary? Irrespective of whether a judgment is lengthy or short, the soundness of reasons, findings, logics, not the length of the judgment, not the number of pages. And the prevalent practice is that if there is a lengthy judgment running into 60, 100, 200, 500, 1,000 pages, then necessarily it's a bad judgment. Judge is just trying to show his punditry to his academics, to his skill, to his verbosity. उसको क्या हिंदी में हमारे यहाँ कहते हैं, लफाजी. A responsible judge should avoid doing lafhaji, verbosity. In English, there is a word, verbosity.
Yes, sir.
Ask someone to put his question.
Good evening, sir. Sir, I wanted to know the importance of judgment and degree and difference between the both.
Exactly. You have seen beehive, madhumakhi ka chatta you have seen?
Yeah, sir.
So judgment is that madhumakhi ka chatta.
Okay.
Hanging on a tall tree.
Okay.
And the honey that is found inside that beehive, madhumakhi ka chatta, that is decree.
Okay.
Ah.
And sir, which is important one? Both are same, equally important?
Why not? The net result produced by the judgment is called decree.
Okay, sir.
You know ki in judgment, what are the components of a judgment? The material facts, discussion of material evidence and relevant law, reasoning or conclusion, what is called finding, then conclusion, then operative part. Mostly it is the operative part of the judgment. Last few lines that are written by the judge at the end, at the bottom of the judgment before putting his signature. That operative part, that conclusion is put into decree. Decree is written in a few lines and judgments are written in pages and pages. मधुमक्खी के छत्ते में कोई छत्ता पूरा खाता है क्या? हनी
नहीं
खाते हैं ना,
जी जी सर।
तो डिक्री जो है हनी है,
ओके सर।
और वो जो मधुमक्खी का छत्ता है वो जजमेंट।
ओके
तो
सर।
हाँ, लेकिन वो ऐसे तो हनी नहीं बनेगी, हनी कहाँ से आएगी? व्हाट इज द सोर्स ऑफ हनी?
Yeah, there should be chatta and the wax.
देयर मस्ट बी, हनी मस्ट बी प्रिसीडेड बाय मधुमक्खी का छत्ता,
Yes.
तो उसी छत्ते से शहद निकलेगी। तो ये डिक्री शहद है, फल है उस जजमेंट का जो पार्टी को मिला या नहीं मिला। नेट रिजल्ट मतलब ग्रांट आर रिफ्यूजल ऑफ रिलीफ, रिलीफ ग्रांट हुई है देन इट इज डिक्री, रिलीफ हैज बीन रिफ्यूज्ड बाय द कोर्ट देन इट इज डिक्री। इन बोथ कंडीशंस इट इज डिक्री। और
Okay.
जितना उसके ऊपर डिस्कशन है जजमेंट में, दैट इज जजमेंट। तो द नेट रिजल्ट प्रोड्यूस्ड बाय द judgment in the end, what is called operative part, the last conclusion arrived at by the court with regard to the grant or refusal of relief is called decree. It is
Okay.
defined in the CPC in section 2. तो ये है मोटा मोटा, उसको सरल भाषा में ऐसे समझो,
जी।
मधुमक्खी का छत्ता एंड शहद।
Yes.
और
Chant is a order decree. Order which we see in few lines, that is a decree which is to be followed.
order is quite different than judgment and decree. Judgment is a final termination of the suit, and order is not necessarily a final termination of the proceedings. But when a plaintiff is rejected under Order 7, Rule 11 CPC, then only an order is passed. Suppose the plaintiff stands rejected on any of the four grounds given in Rule 11 to Order 7 of the CPC. So this order will amount to decree. So nature of order passed would be decree, but it has not been passed on merits of the case. It is not necessary that all the material facts, all the evidence, all the relevant laws must find place in an order. Order can be passed at any stage, interlocutory stage, interim stage, at any stage, and not necessarily ki an order would be always followed by decree. No, judgment is passed after collecting the evidence, providing the parties opportunity to contest and lead their evidence to argue. Suppose कि a civil suit is dismissed under Order 9, Rule 4 CPC. There is no judgment. It's just an order passed in default of the plaintiff. Plaintiff could not appear before the court on date of hearing, therefore suit was dismissed. It is not judgment because nothing has been decided on merits. Judgment is passed on merits. Orders need not discuss the entire merit demerit of the case. It can be passed on any issue, small issue, interim issue, at any stage, interim stage of the proceedings. So this is the difference.
Sir, can I ask you one more question, please?
Yes, yes, yes.
Sir, right now you said as per Rule 9, case can be disposed of or dismissed because of the default of absence.
Yeah.
So here a disposed case can be again restarted in the same court.
Why not?
And is there any time limit in that?
There is limitation period of 30 days. Either it should be from the date of dismissal of the suit or from date of knowledge. If the plaintiff fails to prove either of the two, then suit will not be restored. It will remain dismissed forever, and he cannot be allowed to file a fresh suit based on the same cause of action because Order 2 CPC bars any fresh suit. Suppose the plaintiff could not come to the court on date of final hearing or hearing of the case, and his counsel also did not appear before the court. The option of the court is then to dismiss the suit, or court may adjourn it to a future date. Suppose here the court preferred to dismiss the suit because plaintiff and his counsel did not appear. Then option of the plaintiff is to move application under Order 9, Rule 9, perhaps it is, for restoration of the suit. It will be restored. 9(4), it is 9(4). And if the defendant has failed to appear under Order 9, Rule 7, Order 9, Rule 7, the suit will be allowed to proceed ex parte against the defendant, and if later on defendant appears and explains to the court satisfactorily that he was prevented by any sufficient cause from attending the court on that date, court will set aside its previous order and will allow the defendant to proceed on merits.
Okay,
So
sir.
there are
But
sufficient provisions given in Order 9 CPC.
yes, sir. Sir, but there is a time limitation of 30 days. This is sure.
30 days, 30 days, 30 days.
Okay,
But
sir.
suppose he comes after 2 years, 6 months,
Yeah.
so he will have to make an application under Section 5 of the Limitation Act 1963,
Okay.
stating the grounds, the reasons why he could not come within 30 days. He says that I was admitted in the hospital and was in ICU, and there was nobody else in my family to look after the case and go to the counsel. And the counsel says that I had got no instructions from the client, therefore I could not attend, and the suit got dismissed in that circumstances. And the court is satisfied that this delay deserves to be accepted. Court will accept it. Will
The same court.
condone the delay under Section 5 of the Limitation Act and will allow the restoration application.
Okay.
5
same.
साल 10 साल भी हो जाए तो उससे क्या फर्क, वो
The
जेल
same.
बंद हो गया, सपोज कि मर्डर कर दिया, जेल बंद हो गया,
जी.
अब कौन करेगा उसकी पैरवी, वकील से कौन कांटेक्ट करेगा, क्या करेगा, जब आएगा 10 साल बाद छूट के तब लड़ेगा, अब आप फाइल कर देगा.
In the same court or another court, sir?
People, we allow anyone to come anytime and knock the doors of the court. Courts are fond of getting the sound of knocking of the doors of the court. कोर्ट्स को बहुत अच्छा लगता है जजों को जब कोई दरवाजा खटखटाता है. मैंने तो पूरे करियर में देखा नहीं कोई दरवाजा खटखटाया, दरवाजा खुला रहता है, सब धड़धड़ाते चले आते हैं कोर्ट में. अब तुम लोग नए वकील हो, खटखटाओ दरवाजा.
जी सर.
चलो और सवाल.
So much. Thank you so much.
Sir, last question. How to master the art of judgment writing for college competitions and the judiciary exams?
Sound judgment, a sound judgment can be written in a civil case by the judge only when he is well familiar with the law of appreciation of evidence in civil cases. If the judge doesn't know the law contained in the Evidence Act, the law propounded by the Supreme Court of India in the form of rulings over the decades, then it is very, very difficult for a judge to write a very sound, very good judgment in a civil case. Those lawyers, those students who are participating today in the past in a civil case in an excellent manner, so then they must read, they must know how the evidence is appreciated in civil cases. You know the source of evidence, whether it is a criminal case or civil case, is the Evidence Act. It uniformly applies to both types of cases, whether the nature of the case is civil or criminal. The same Evidence Act is applied. But you know the provisions of the Evidence Act have been interpreted by the Supreme Court quite differently over the decades. There are hundreds of leading rulings of the Supreme Court which a judge, which a lawyer, which a student aspiring to appear in judicial services must know. Otherwise, it's a very difficult area. Appreciating evidence, deriving a finding from evidence requires a lot of knowledge, skill, experience. Of course, a new entrant in judicial service or an aspirant who is just trying to get a berth in judicial services is not supposed to know every leading case that have been pronounced by the Supreme Court over the decades, but at least a few dozen leading cases he must know in order to have clarity in relation to the appreciation of evidence in civil suits and how the findings are derived. So I would suggest you read my write-up available on my website, lawhelpline.in. The name of the article is Appreciation of Evidence in Civil Cases. And of course, at the same time, you must also read the subject which we are discussing today here, how the judgments are passed in civil cases. If you read these two subjects thoroughly, you will have sufficient clarity with regard to the manner of passing of judgments in civil cases.
Sir, which judge's judgments should we refer to for mastering this art?
Not a single judgment of a single judge. There are number of, at least they must know 50, 60 judgments, leading judgments, which are referred to in my write-up, appreciation of evidence in civil cases. Only then they can understand. Just by reading one judgment on a few points will not be sufficient. Today, I am attending your session from the library of Judicial Academy, Jharkhand. If you can see the ambience of this library, it's a very good library, very well arranged, very beautiful place. आप वीडियो ओपन करो तो कितना सुंदर लाइब्रेरी यहाँ लगी हुई है सामने photographs of many former chief justices of India are also here put on the wall. Professor Sahab is showing you people.
Amazing, sir. Thank you so much, sir, for giving us this tour of the library.
So we should now conclude. Hello.
Yes, sir, we can conclude. Okay, thank you so much, sir.
Right. All the best.